Welcome everybody. This is a talk titled, You the Jury? Is this case a prosecutor fallacy or not? By Nigel Marriott. This is hosted by the Forensic Data Science Laboratory at Aston University. It's organized by the Royal Statistical Society, Statistics and Law Section, and West Midlands Local Group. So we're going to have a few little introduction pieces. I'm going to talk about the Forensic Data Science Laboratory first, and then Amy is going to give an introduction to the talk. So this is where the technology suddenly doesn't work. There we go. So the Forensic Data Science Laboratory conducts research to develop methods for evaluation of forensic evidence. And these methods are based on relevant data, quantitative measurements, and statistical models. They work in a framework which is transparent and reproducible, intrinsically resistant to cognitive bias, uses the logically correct framework for evaluation of evidence, the likelihood ratio framework, and is empirically calibrated and validated under casework conditions. So we do research on methods for calculating likelihood ratios, methods for calibration of forensic evaluation systems, and for validation of forensic evaluation systems. We also do work on understanding of likelihood ratios by lay people, such as judges and juries. A lot of this is applicable across different branches of forensic science. Particular branches of forensic science we've done work in include forensic voice comparison, forensic comparison of fired cartridge cases, forensic comparison of facial images, and forensic cell site analysis. We also do training. If you're interested in training, we have a course which is Concepts of Forensic Inference and Statistics. That course is a master's level course, but it's continuing professional development. So it's aimed at people who are already working in industry. To facilitate that, it's aimed to be about 1 day a week of work spread over about six months. And it includes a competency assessment at the end. If you're interested in finding out more about the Forensic Data Science Laboratory, here is our website, and I'll give you a second to look at that, and then I will hand over to Amy.
Great. Do I need that? Sure. I haven't got a shirt pocket to put that in. Right. Okay. Thanks everyone for coming today. So I'm the chair of the Royal Statistical Society Statistics and the Law Section, and this has been jointly organised by the section and the West Midlands Local Group over here. And thanks very much to Jeff and Aston for hosting it for us. So I just wanted to briefly introduce the stats and the law section and tell you some of the things that we're doing before we start. So the purpose of our section is to enable the RSS to make informed and hopefully influential contributions to the administration of justice. We work in training, guidance, research, dissemination of anything that's at the intersection of law, forensic science, forensic medicine and statistics. And we cover both criminal law and civil law. So we've got a website that's up here on this slide. And we run lots of events like this, 3 or 4 a year normally. That's not all we do. We also do things like responding to calls for evidence in this area. We produce a lot of training documents, do training sessions, produce guidance on particular topical issues. If you want to hear about more of our events, we have a mailing list, and you can join that by just going to that link. If you scroll right to the bottom, there's a button for joining the mailing list. And you don't have to be a fellow of the RSS to do that. Anyone can join. And many of our events are free. Okay, so what are we working at the moment? So I've just got one slide before we get started. So partly as a result of the Lucy Letby case and some of the issues that have been publicised around that, we've been working with various organisations around the UK to try and improve use of statistics within the law. And I think my aim is that I want practitioners from both forensic science, law, judges and expert witnesses to recognise when there are statistical issues that need addressing, firstly, and then secondly, to use professional and qualified statisticians to deal with those issues. And as part of that, we've got several initiatives ongoing at the moment. We're working on some guidance for different areas in the legal and forensic sectors. There's some existing guidance that we've written in the past that's on those links there. We're also working with the MPCC to produce some guidance for policing, and we're planning an update to a guide with the Inns of Court College of Advocacy, which we're hoping to get done next year. That's for barristers. We've also worked on training, so we've done some advocacy training with the Faculty of Advocates up in Scotland, and we're planning to repeat this with Inns of Court College of Advocacy down in England, and we're hoping to do something with the Bar Council as well, and we're in discussions with them. We're also assisting the forensic science regulator with various statistical points in the new code, but we'd like to get involved with policy more broadly, particularly around use of expert witnesses, outside of those covered by the forensic science regulator. And we're also working to try and encourage young statisticians and statisticians who've maybe not thought about it before, don't necessarily have to be young, to get involved in expert witness work. And we're looking to put together a register of expert witnesses with the Royal Statistical Society. And that's part of helping people in the sector use qualified statisticians. We want to help give them access to people who have the skills and interest in helping them. So that we kind of want to help them understand what the statistical issues are and then give them the access to the statisticians that they need to help. Okay. So if you have any more ideas to add to my list, I'd be happy to hear them. And that's my email address there if you want to get in touch, or it's also listed on our website. So do you want to come up and say something before we get started?
Is it? Yeah, I'm up. Hi everyone, my name is Christian and I'm the chair of the West Midland local group. We also organize a series of events like this one, sometimes joined with other sections, sometimes just on our own. Our next event is our annual general meeting. It's going to be taking place at the University of Warwick, and we're going to have Professor Jen Houghton, that is here, speak about the Lucy Letby case. But it's completely free, so all our events are free, so you don't need to pay anything. We also have a website where you can register to our mailing list, and it's just on the Royal Statistical Society website. You can easily find us. And if you have any ideas for any event that you would like to organize, please let me know. We also have some vacancies on our company. If anyone is interested in joining us, please let me know. We tend to organize like 3 or 4 events a year like this one, around the Midlands, as you can imagine. So thank you, and I think now Nigel would like to start.
So we'll move on to our speaker, Nigel. Just get his slides up. So Nigel is an independent chartered statistician based in Bath. He's a fellow of the Royal Statistical Society and a member of the Academy of Experts. And amongst many other things, he's worked as an expert witness for around 20 years, looking at the use of sampling and surveys as well as discrimination claims. And he's also written guidance for non-statisticians on how to draw conclusions from data. And there's a few links to that on the RSS sign-up page if you want to see. And Nigel's also currently the chair of the Business and Industry section of the RSS, and has previously been chair of the Quality Improvement section and a member of the Professional Affairs Committee. So I'll hand over to Nigel. Do you want me to flip it on?
Kick it on. Thank you very much, Amy. Good evening, everyone. And first of all, thank you very much to the West Midland Local Group and the Stats and Law section for inviting me to give this talk. This is actually the second time I've given this talk, because I previously gave it to the Academy of Experts back in March. So I know it worked very well here. Now you'll see on the screen at the moment a QR code. I strongly recommend you now get your phones out and open up the poll, because you're going to have a chance to vote on whether this person is guilty in this case. So if you're not got your phone out at the moment, later on, before the polling actually starts, you'll see it again, the QR code. I'm going to advance the slide now, but there will be a second opportunity to open up the form just before you actually start voting. So, as Amy introduced me here, I'm both a member of the Royal Statistical Society and a recently joined member of the Academy of Experts. So for those who are interested in expert witness work in UK and indeed worldwide, actually, I can recommend the Academy of Experts. They do have members from all over the world, not just the UK. And so I joined them 2 years ago, and it's certainly been extremely instructive. I thought I knew the duties of the expert, but when I went on the course, the foundation course, boy, did I really learn why they are the duties. And seriously interesting stuff. So I can thoroughly recommend them. A few links at the bottom there. I do blog about statistics there. So if you search for Nigel Marriott, you should find my blog, as well as my social media feeds on Twitter and LinkedIn. So what the structure of this session is going to be is I'm going to take you through this case, which I instructed an expert a few years ago. And I'll give you the background, and then we'll go through the evidence in the case. And after each piece of evidence, you'll have a chance to vote using the form. As I say, the QR code will appear again in a minute. And at that point, once you've voted, we'll go through to see how you voted overall. And then that'll be your opportunity to tell me, why did you vote that way? What was it about the evidence you heard that made you vote one way or the other? So you have an opportunity to ask, at least give an opinion at that point. And that goes to people online as well. Ian, who is managing, will be managing the questions in the chat box. And then I'll wrap up the case, giving the verdict and into the implications of that case. And I'll take questions then. But then, as I'll explain, there was something about this case made me think of Sally Clark, an infamous case, anyone who knows about statistics and the law. And as I want to explain a personal perspective on that, because I thought I knew what that case was about. And then I found out I didn't know what the case was about. And I want to share what I learned from that. And maybe it'll be stuff you didn't know what that case was about. So that would be the last part of the session. So the case of Dr. X. Now, this case here, the judgment was published. So it is available. If anybody's interested in seeing the judgment on the case, you can email me or Amy afterwards, and I'll email the judgment. It's not up on the General Medical Council website, because it seems to be the policy of General Medical Council to put judgments up for 12 months and then take it down. So, so I'm not going to name people here, and I'm not even going to mention professional society here. But doctors have to take various professional exams, and this professional body had this exam here, of which 673 candidates entered. And our person today, Dr. X, was one of those. And 137 multiple choice questions split between morning and afternoon, 2.5 hours in the morning, 2.5 hours in the afternoon, between 5 and 11 choices per question, with only one of them correct. And given a pen and paper in order to do some working out, but that had to be handed back in afterwards. Now, this professional body, because it's computer-based, they routinely screen the results after people have taken the exam, and they noticed something a bit odd. An unusual degree of coincidence between the answer to Dr. X and another candidate, Dr. Y. And as a result of that, they decided they opened an investigation and charged Dr. X with multiple counts of dishonesty. And in the UK, the Medical Practitioner Tribunal is run, I think it's run by the GMC, I'm not quite sure who runs it, to actually hear these allegations. And I was instructed to write an expert report and to give evidence at this tribunal. So we're going to look at two of these allegations. The most serious was count one here. during the exam, she copied the answer from another entrant and submitted those her own. So cheating in the exam through copying the answer from another person. That's the most serious allegation. And we're going to look at one of the other accounts here that when asked how many times she had previously sat this exam, she gave an incorrect answer. But the most serious one by far is the count one, which is the one you're going to vote in. And the tribunal here, the burden of proof or standard of proof here is akin to a civil proceeding. So whether it's more likely than not that the event occurred. So although it had the sensation of a criminal standard, I mean, it's a professional misconduct here. The standard of proof is not criminal standard, it's a civil standard. So your last chance to open up the Google form here. There is a logistical reason. I strongly recommend you open this up and vote. I was hoping to be able to show on the screen the results of the vote once everybody had voted. I'm not going to be able to do that logistically, but you will be able to see it on your phone, and I will see it on my phone as well and explain it as I go through this. So this is your last chance. And as I say, for people online in the chat box, the link should have been provided, but otherwise use your phone to scan this on the screen now, and you'll be able to get this phone open. And what's going to happen is you're going to see 7 pieces of evidence, starting with my expert evidence, and then 3 for the prosecution and 3 for the defense. After each piece of evidence, you'll be able to vote on what is the probability that Dr. X is guilty of count 1, i.e. cheating through copying, based on all the evidence you've heard up to so far, so not just that particular piece of evidence, everything you've heard so far. And I'm giving you a scale from 0 to 100%. To 0% is the 0, 10 obviously 100%, and the numbers are intended, you just add a 0 to it, so 2 will be 20%, 4 will be 40%, etc., etc. So, everybody here got a form open, ready to vote? Yeah. Right, it worked very well when I did this back in March. It was great fun. So, let's start with my expert evidence. So, the reason the professional body opened the investigation was that they observed what they thought was an unusual degree of coincidence between the answers of Dr. X and another candidate, Dr. Y. So I was instructed to verify whether or not that degree of coincidence truly was unusual, and therefore they were justified in opening an investigation, or whether it was within the bound of normal chance. So this, of course, is a classical statistical problem for us statisticians. But by the way, I should actually check. In the room here, are we all statisticians, or are there lawyers present as well? I know we've got one there. Online, I don't know how many. We have a mix of lawyers or statisticians and stuff. Anyway, let's have a look here. So, now again, just to, not reveal too much about the, personal details here, I'm actually referring to candidate A and candidate B instead of identifying who was Dr. X and who was Dr. Y here. But one of those doctors, out of 137 questions, got 66 right, and the other doctor got 61 out of 137 right. Now, on average, across all 673 candidates, 80 out of 137, or 58%, was the average performance there. And so, the assumption here is that the candidates should be answering the questions independently of each other. We're going to expect sometimes they will give the exact same answer. That should happen. But, how much coincidence would we expect before we start to get suspicious about what might have happened? So my null hypothesis here is going to be that let's assume nothing untoward was happening here. A and B answered independently. To what degree of coincidence could we expect? And so I need to fill out this table that we actually see here. I'm just going to if the mouse No, I don't think the mouse is working here. So I need to fill out this table here. And all I need to do to fill out this table are two numbers. RR, which is the number of questions where both candidates got it right, and SS, which is the number of questions where both candidates got it wrong, but showed the same wrong option. We say a statistician that this is a table with 2 degrees of freedom. Because if I know what RR, let's say it was 30, then I can fill out this table here. I can say, well, if they've got 30 questions right in common, then this candidate B, would have, got, well, out of the 61 that it got right, 30 questions would have been also answered correctly by candidate A. 1 question here, candidate B would have, candidate A would have got wrong. And likewise, if that was 30, then it followed that candidate A, or candidate B would have got 36 questions wrong when candidate A got it right. Yes. So all I need to fill out this table is to work out what are these two numbers here. All I have to work out is why we say this will be a statistical test, chi-squared test, with 2 degrees of freedom. And then with the null hypothesis, I need to then say, well, okay, what values of SS and RR would I expect if the candidate were answering independently? And so basically, I assume that this null hypothesis is true. I then have a disparity between what actually happened and what I expected to happen. And I need a way of measuring it. That's the chi-squared statistic. And then I'll apply a hypothesis test with that chi-squared statistic to say, well, okay, what's the probability of obtaining that observed table, what actually happened, if this null hypothesis was true? That's going to be the p-value. And then I'm going to compare that with a significance level to draw a conclusion. So that's what you're going to see from my expert evidence here. Now, I will just mention that anybody who does statistics at university, say a modular statistics at university, when you're not on a stats course, should come across the chi-squared test. It's probably one of the most basic tests that get taught in pretty much all modules of stats. So I'm hoping I'm reminding people either of their pleasure or nightmare of having done this at university. So, now, one thing I could do straight away here is with the knowledge that candidate B had 61 right and candidate A had 56 right, is to work out, well, what was the maximum possible coincidence? So I hope you can figure out why that is 61. Of all the, the maximum possible coincidence would be this scenario here, where both get 61 right. They both get 71 wrong by choosing the same wrong option, leaving 5 questions that candidate B gets wrong while candidate A gets right. So there's a maximum of 132 coincidences out of 137 here. But what is the expected value here? Let's see. Now, one of the things I want to get across here about why it's so important to get statisticians in expert witnesses, it's because the chi-squared test is so widely taught. There are lots of other experts out there who may think they know how to do this, and they could fall into traps. And this is the first trap that somebody who thinks they know the chi-squared test would fall into. They would come up with this table here for the expected number of coincidences. And that is to say, okay, I would expect, if they're answering independently, 29 questions where they get both of them right, and 10 questions where both of them get it wrong but choose the same wrong answer. And I've seen people do this and make this mistake. You could only do this or arrive at that table if all questions are equally difficult and the candidate knowledge is the same across all questions, which is unlikely to be true. And we've all done it. We know that some questions are hard, some questions are easy, some of us know this bit and other bit people know that bit. But what you will have been taught at university in the basic chi-square test 101 is, okay, 29 here equals 61 times 66 divided by 137. And that is a trap that other experts who think they know statistics could fall into. That did not apply here. Now, I went through this and, looking at the data here, and I'm thinking, okay, how am I going to construct this expected table? I need a model to say, okay, what would I expect if people aren't doing independently? And I based it on the other 671 candidates. Those X and Y are excluded from this because they are the two doctors in question where it's suspected that we have a coincidence. And based on that model, I arrived at this table here where I said instead of 39, if I'd fall in this trap, I expect 55 coincidences, the 36 where they're the same and 19 where they're different. Now, much to my surprise, I could actually use a relatively simple model. I did not expect it. I went ahead and fitted what I thought. Let's start with the simplest model. Let's assume that the number of correct answers they have in common is a function of two things: candidates' overall ability and the difficulty of each question. That's what I did. That's the simplest possible model I could have done. I fully expected it to be a bit more complicated than that. I thought, okay, surely we'll find some candidates that did better on the morning paper and poorer on the afternoon paper, and others vice versa. That would be an interaction of some kind. I was greatly surprised to find actually this model was pretty good. This is all I needed to do. Now, this then raises up another issue that being a statistical expert that you need to be conscious of, and that is to read your instruction. I was not instructed here to find the best statistical model for the purposes of an academic paper. My instruction was whether or not the professional body would justify in concluding that this is fact coincidence was, anomalous. It was, unusual and worthy of investigation. So yes, I'm sure there are many statisticians in this room who are better statisticians than me, build a better model here. But in my judgment, I didn't think it would greatly change those numbers. Maybe it'll get up to 57, 58 coincidences, in 55 here. But in my judgment, based on what I thought at that point, I did not need to go further. And that's quite an important step to remember here. I'm not writing an academic paper here. And in the end, you've got to also remember another thing. You'll be writing a report that'll be read by the court by lawyers who are not statisticians. This model is comparatively easy to explain. A more complex model would have meant a lot more explanation and could have confused the audience here. And this was the actual number of coincidences. So I set up a scale here. I expect 55 coincidences, 36 right, 19 wrong, same wrong option. The maximum coincidence that you could get was 132. So I've effectively now got a numerical scale here that I can communicate to people. And even if you're not a statistician, just compare numbers is something that most people are capable of. And obviously, I just tell you, okay, yes, actually, yes, we can see here, there were 122 coincidences here. So we were very much close to the maximum coincidence scale here. But still, could that have happened by chance? Well, I then go ahead and say, well, what if that was, there was no cheating, collusion, or anything else things going on here. This is a chance to current. If I assume that null hypothesis is true, what's the probability of ending up with what we actually observed up here through chance alone? And, well, I go through here, I calculate the chi-squared statistic here with 181 on 2 degrees of freedom, applying something called Yates correction, quite often talked about in back courses, but I felt that was appropriate here. And your p-value here, if you put that formula into Excel, it will calculate it for you to equal chi-dis 181,2. And the p-value is 4.1 e to the minus 40. That notation there is 10 to the power minus 40. So 4.1 times 10 to the power minus 40. So, well, you've got to remember, we need to take into account that these candidates have got 66 right and 61 right. You know, need to take into account the candidate's own ability in addition to the difficulty of a question. So I built a model that allowed for that. You know, that obviously it's actually a good question you asked there, Jane, because let's say you had two really strong candidates that they got 120 right each. And by definition, we would expect this number to be a lot higher, the RR, and, you know, the test number to be a lot lower. So that's why I felt that was the model that was actually needed here. So, this p-value is incredibly low, but is it low enough for me to conclude that I can reject that null hypothesis in favor of an alternate hypothesis? Said, well, actually, I reject the hypothesis that this could be a chance to, sorry, that be very precise here. The null hypothesis is based on the assumption of independence between the responses to Dr. X and Dr. Y. If I reject that, I've got to conclude that it was not independent and something could explain it. But to do that, I need a significance level. Now, this is track number 2 an expert might fall into who has done a modular stat but doesn't fully understand these stats. Because traditionally, and I put it in quotation marks here, traditional hypothesis testing said use a significance level of 5%, 1%, 0.1%, something like that. And just for the legal crowd in our audience here, statistical significance does create confusion. I think the best way to think about p-values is to think of burden of disproof. The term burden of proof is commonly used in legal circles. We statisticians sort of invert that into burden of disproof. And so the question is this p-value low enough such that we disprove and can reject the null hypothesis of independent responses, include that responses are anomalous or not independent of each other. So there are 673 candidates, and remember the professional body here screens everybody. It looks for coincidences between every pair of candidates. Well, how many pairs of candidates are there? We have 673 in total. Not difficult to work out. 226,000 pairs. So if I apply a screening, with a 5% significance level, what that means is, just through chance alone, I would expect 5% of that 226,000 to be flagged up for investigation. And that equates to 11,000 pairs to be investigated. There's no way they're going to do this. This is known as the multiple comparison fallacy, or a variant of that here. And it's a trap that, experts who aren't statisticians could fall into here. So what the professional body were aware of this, and they applied something called a Bonferroni correction here. And that dropped the significance level to around 1 in a million. But, and I didn't have a problem with what they did there, so I kept that significance level. Now, this is where things got a little interesting. I'd not seen this before. In this case, they didn't use the probability that I came up with, which was 4 to 10 power, up to 10 to the power of minus 40. They used the concept of heads value. So they said, well, okay, 1 in a million equates to the probability of tossing 21 coins and getting 21 heads. So if you do 2 to the power 21, it comes to around a million. And this is the way they express probability throughout the whole trial and in my paper. So I adopted that, thinking it was a good idea. I thought, okay, yeah, actually, maybe that makes probability a bit more tractable and easier to think in terms of 21 head, rather than the number that I came up with, which most people are not going to be able to put that number in their heads. However, and that's why I'm going to talk about Sally Clark, there's a big however to this idea, which I thought was a good idea. That p-value is 1 in 2,400 trillion, or 131 heads. So it was way above any statistical significance. And this is one of the reasons why I felt that the model I came up with was a reasonable one. There wasn't much gained by putting in more complex models. I could conclude that the difference between the observed responses and expected responses under the null hypothesis, that responses were independent, statistically significant, and I am going to reject that because they are implausible if that is true. And the observed coincidence is indeed anomalous, justifying opening investigation. So that was my expert evidence. Could you please go ahead now and vote? Based on my expert evidence, what is the probability that Dr. X is guilty of count 1, that she copied the answers from another entrant and submitted those as her own? So please vote now with that scale there. So countdown, 3, 2, 1. Right, now the rest of the evidence is quicker to present. I spent some time on this statistical expert evidence because I wanted to draw out some issues about the potential trap somebody who thinks they're an expert could fall into here. So we're going to hear your prosecution's evidence, and I'm going to get you the headings of opportunity, motive, and means. Exhibit 2 is opportunity. So the professional body commenced this investigation. Now, 673 candidates, they did not all sit the exam at the same time in the same location. What this body had was a testing center. I may have had multiple testing centers, actually, with a bank of about 8 computers. I think there were 8 computers in a room. They're only up to 8, and I think actually there were 2 less than the number. I think there were only 6 people in this room at that particular time. The first thing they noted, that Dr. X and Dr. Y were in the same room on the same day. More than that, they were sat next to each other. But the layout of the computers was slightly unusual. So you had this desk with dividers here, so that in theory you couldn't see what was happening on the other desk here. But the computers were not placed in the center, they were placed to the left. And so on that basis, they sat down, they actually went to the center, sat down, and decided that for Dr. Y to see the screen of Dr. X, they would physically have to, really crane his or her neck around. Whereas Dr. X, she only had to lean back a little bit and she'd be able to see the screen there. So that was the conclusion they drew from having visited the center. Please now vote again on, so once you voted on the first one, you can click next and you'll go on to the second vote, where you can now update your probability of Dr. X being guilty of copying the answers. So the countdown, 3, 2, 1. Motive. So at this point, they then interviewed everybody who had been in that room that day. And obviously their suspicions were focused on Dr. X at this point, but they also interviewed the other candidates in the room. And during the interview with Dr. X, she incorrectly said that she had sat the exam 3 times. Now, for this professional body, you could take this exam up to 6 times before you couldn't take it again. In reality, it was the 6th and final attempt. And I told you there was a second count that she would charge to, count 2, that she gave the incorrect answer to this. I'll tell you now that count was proved. The tribunal decided this count had been proved. She did indeed give an incorrect answer to this question. She said 3 when in fact it was the 6th and final attempt. So please go on to the third vote now. And update your probability based on this. So, countdown, 3, 2, 1. And we'll go on to mean. So we've done opportunity and motive. So they then went and had a look at the papers. Now, remember, each candidate got a pen and paper to do their working out on, but that had to be handed in back after the exam. So they looked at this, and 2 prosecution witnesses during the trial gave the following statement in court and in their report. It said, the notes were unusual and they were indicative of somebody writing details from a question in order to identify the question and the possible answers on the screen. My suspicions were also aroused that there was no question numbers on the note, just details from the question. The notes were unusual and it was redundant for a candidate to make notes in the way Dr. X did on the basis the information in respect to the exam was already on the screen. Now, as I say, the 7 pieces of evidence I'm showing you. Now, I wasn't there for the whole trial. I'm going by what is in the judgment, which, as I say, if you email me or Amy afterwards, you'll be able to get a copy. It was pretty clear from the judgment that the other 6 pieces of evidence I'm going to talk about, it didn't appear to be any dispute, major dispute, or between prosecution and defense. This is clearly the center of dispute between prosecution and defense in this case. They obviously spent a lot of time on this, to the extent that during the hearing, there was an application by one side to introduce additional evidence, and the tribunal had to make a decision on whether that additional evidence should be introduced. So that concludes the prosecution case. Please update your probability in light of everything you've heard so far. Yeah. 3, 2, 1. Let's move on to the defense. And we'll start with means. Now, this is a computer-based exam. So that meant, they were able to employ something called double randomization. And the defense posed the question, how was it possible for Dr. X to cheat, given that the order of the question was randomized? The Dr. Y answered the question in a different order to Dr. X. The first question for Dr. X might have been question 40 for Dr. Y, and vice versa. So the question orders are completely random. Secondly, there was the options for each question, 5 to 11 options, were also randomized. So when Dr. X is answering the first question that Dr. Y has answered, the correct answer might have been A for Dr. Y, but option D for Dr. X. So the defense posed the question, how did she overcome that double randomization across 5 hours, 2 papers, about 70 in the morning, 70 in the afternoon? Update your probability, please. So 3, 2, 1. Motive. Now, remember, count 2 was proved. Dr. X gave an incorrect answer, saying she'd done this. This was her third attempt. In fact, it was her sixth and final attempt. So in mitigation, defence counsel submitted, the tribunal was aware of serious issues in Dr. X's personal circumstances. The interview with Dr. X took place during these difficult circumstances. She was extremely nervous during the interview, a point confirmed by one of the prosecution witnesses, and the consequent stress and strain explains why she gave an incorrect response. And she'd also taken 2 other exams that week and had sat many exams over the past few years. So that was mitigation for count 2. And Dr. X's witness statement herself, remember this is all in the judgment, it was really overwhelming from the beginning. It was so stressful. I was already shocked they were accusing me of cheating. I was really nervous. I couldn't think straight. So, please update your vote now. And 3, 2, 1. And we'll come on to the final exhibit, which is opportunity. Now, as well as I think, 6 candidates in the room, there was also an invigilator. The invigilator sat behind the bank of computers, so he or she could see the backs of the people sat at the computer. In addition, there was a CCTV camera, which another invigilator was watching. And the defense counsel asserted, and the prosecution witness accepted, that in order for Dr. X to see Dr. Y's screen, she would have had to move her chair back about 30 to 50 centimeters to see around the divider. And she would have had to have done this multiple times during the exam. So it's not like lean your head. You'd have to do more of a physical movement, which the prosecution witness accepted. And both of these invigilators signed attestations after the exam saying they had not seen anything untoward. And they were included in my bundle. So I saw those attestations there. So your 7th and final vote, this will be your verdict now. Remember, this is on more likely than not, it's the standard of proof. So I don't know, that might equate to about 7, 8, 9 out of 10 here in this study. 3, 2, 1. Right, now, on your screen, let's just hold off for 1 second. As I say, I was hoping that you have the ability to show the responses on the screen, but you'll be able to see it on your phone. I can see that 56 people have, oh, no, we're up to 57 now, 59. I'll give it a few more seconds to, right, we're up to 63. So 65, yeah, it's all coming in now, the verdict. We've got totally over 200 people online. There's, hold off, we'll just allow all these responses. Look like we might have settled down on 68 responses. Now, on the screen that you should be on, there, somewhere at the bottom, it said, see complete or earlier responses. So, if you click on that, you will actually be able to see the frequency distribution of the data. Now, I was hoping to show this on the screen, but I'm going to read it out. Question 1, 74 responses. The mode response, the most common was 5 out of 10. The median would look to be about 7 out of 10, 70%. But I would say probably less than 10 or 20% people gave a probability of less than 50%. By the way, are people seeing this on their phone? You are, yeah. I'll just take a poll in this room. Hand up if you gave a probability of 50% or more in answer to this question. Oh, Jane, I'm so disappointed.
Trying to go for ambitious.
I'm sorry?
I was trying to go for ambiguous.
Well, yeah, on 50%.
So
Yeah. Why did you want to go just 50%?
the likelihood ratio of 1.
I'm sorry?
The likelihood ratio of 1.
Yeah, right, yeah. The key point here, all this evidence shows is I've got to I can reject the hypothesis that responses were independent. That in fact there was some dependent. But it doesn't point to which one of the two candidates. Is it X or Y that might have cheated? You may have seen on the slide, it was common ground that these two candidates did not know each other. Because if, let's say, you revise together for this exam, then you might expect the degree of coincidence to be higher. Or if they colluded together to cheat, through some secret signal, it'd be higher. But I literally said on the slide, I didn't say it myself, but it was on the slide, it was common ground between prosecution and defendant, they didn't know each other. The point is, the maximum probability is 50%. You should not have given anything higher. In fact, I would say 49%, but you've got to allow for the possibility of a freak here. So 4 out of 10 should have been the maximum. And yet the majority of people online in this room put in a figure higher than that. Now, what you might have been thinking, well, she was charged, so X is therefore more likely to be guilty than Y. For all you know, this professional body took against X. The only evidence you've heard at this point is that the null hypothesis of independence can be rejected. That is all. So let's go through all of the charts, and then we'll see how it changed, and then we're up to 78 responses now. On number 2, so I can see the mode is now up to 6. I would say median and average is about 7 or 8 out of 10 there. I think it's been a shift. This was the observation. They were sat next to each other, and Dr. X could actually see the screen in theory. Then I told you that a motive, that this was just some final attempt. The mode is now 90%, and the median must be about 80% now. So the probability of guilt is rising. Certainly on the civil standard of proof that applied here, I think the majority have now said the prosecution has made a case for a guilty verdict. Let's move on to the 4th exhibit, which was the notes themselves, the prosecution asserting that it looked like that they were being written. But as I say, this was heavily contested by the defense. So this was contested evidence here. So prosecution by this point looked like it made a case. You've still got to hear the defense, but it looks like they've made a case. At the very least, if a judge, I'll ask my wife if she's a lawyer by training, but at this point, the judge could have decided that you have made a case out, we're not bothered with defense. Yeah. So it looked like they've made a case. Let's move on to the defense. So the first thing I told you was that it had double randomization. Immediately, a whole bunch of you shifted. I would say the majority of you are still saying tilted toward guilt, but you're not. I would say the median is probably about 6 or 7 out of 10 now. Then you heard mitigation in favour of count 2. I would say that shifted a little bit. Still the median probably about 6. And then you heard that the attestations, nobody saw anything. And I would say that you probably ended up about 50-50 now. Certainly, I don't think you've met the standard of proof as a jury. I think you'd have to say not guilty on that list. Now, before I reveal the verdict, and I believe Ian is monitoring online, did anybody want to say why they voted, your final verdict? Let's hear from those who still think that you've got a probability of 70 or 80% that she's guilty. Who wants to say why? Anybody here? Yeah. I should say, by the way, just to benefit people in this, I am partially deaf, so I may struggle to hear you. If you could pick up Ilya top.
To keep my notes. Two candidates are getting randomised questions. The numbers mean nothing, but the text stays the same. Surely the letter and the answer means nothing, but the text stays the same. So, if I see your paper, I would need to write down text and text the answer, because if I said question 4D, it would lead to that.
Yeah.
I thought there was a way to defeat the randomization by ignoring that question number or the letter of the answer, whether it be 5, 6, 7, 8, or 11 turns.
Yeah, yeah. Okay. We'll take one more in this room on guilty. Those who are sort of like 70 or 80% guilt. In this room, anybody else? Okay.
Pass the mic so people asking questions, because so people online can hear.
Yeah, yeah. Let's see if there's anybody online that is giving any explanation of a guilty vote.
Is there anyone online that like give pen?
Do we have one? No. Okay. So let's go to those who, in the end, gave a probability of less than 50% guilt, as they are not guilty, definitely not guilty. Anybody here want to explain why they voted like that? Jane?
So I think, to my mind, two bits of them to be weighed up. One is, how do you get around randomization? And the other is, what do you make of the opportunity stake? And of course, what we couldn't do was give us a lot more information about those notes.
Yeah.
Because I think it's a very good point about the absence of the numbers and so on. And I'm assuming, I suppose, that the CCTV had been reviewed after the question was carefully reviewed.
Yeah.
So, feelings about the best way of phrasing the question.
Yeah. Anybody else want to give an explanation why you might get up?
It's about desk arrangement, or
Oh, sorry, about a desk arrangement.
the candidate know about the desk arrangement.
Given you heard Dr. X say that she has sat multiple exams, I suspect most candidates would have had experience of that room.
Did she know that Y's computer would be visible to? In other words,
I don't think that point is covered in the judgment. I'm sorry.
that seems to be.
Yeah, yeah. I mean, obviously, the tribunal will only put in the judgment what they think is relevant for the decision, but though there's obviously lots of other evidence there that you may not have heard of. So, but yeah, that's a very interesting point.
Another point struck me with sort of data shift when you gave the evidence that the two vigilators on the day said that they'd seen you towards. How else could they have answered? Are they going to say, I'm sorry, I was fast asleep. I wasn't paying a blind bit of attention to what was going on. What could they say apart from, I saw nothing?
Yes, exactly.
I think that I let that affect at all.
Yeah, yeah.
What could they say? Otherwise, they're admitting professional incompetency.
Exactly. And that was made at Academy of Experts as well. Somebody made the same point there that they, in their experience, because the Academy of Experts has experts in many fields, including medical experts. So they've been in this situation, and some of them weren't that impressed by the attestation. But the court ultimately are not medical experts. You know, they have to rule on that. Online, have we got any more comments there, Amy?
I was just wondering if Ian, do you want to say it? Pete, you say the questions online?
I don't know. Can you hear me?
Yes.
Okay, there's a couple of good questions, but mainly about the details of the case. I'll read them all out, and then there's only 3 or 4.
Yeah, well, we can't actually hear it. Could you say it's like again?
Can you hear me now?
Yes.
Okay, the first comment was that it was highly improbable that they would share so many answers indicating someone cheated. She could look at his screen. He could not look at hers, supporting that she cheated. The next comment was, if she was cheating, surely given the circumstances, then Dr. Y would have been complicit in the cheat. And then another question, did they know each other? If they revised together, there could have been more similar answers, but I think that you've said that they didn't. It's been confirmed, or it wasn't disputed that they didn't know each other. And another possibility, is it possible that an exam proctor was monitoring the CCTV and relaying the answers? So that's a alternative hypothesis, which I know that you've got some coming up. So I'll stop there.
Yeah. Apologies for not pointing that out clearly, though it was on the slide, but it was common ground that they didn't know each other, and collusion was not being considered as an explanation here. But you're right, it did go through my mind. You'll see in a minute that I did put that forward in my report, but then I was told afterward this is common ground. There's,
One. I still can't get whether a woman found to spend 5 hours acting like nonsense. Looking around this, and these two invigilators were assisted for most of that 5 hours. That point, it's that there's can't video.
Yeah.
It's
2.5 hours in the morning, 2.5 hours in the afternoon. Yeah.
just not.
It's, right.
3 more questions.
Yeah.
Right to that.
Yeah. You repeat that, please.
Is there any evidence to disprove the counterfactual that Y was copying X?
Well, that was basically assumed by the prosecution simply because the physical layout of the desk. So I'll just quickly skip back to that. Exhibit 2. That in order for Y to copy from X, which you're right, after I've done my expert bit, I've got to conclude that if there is copying going, it could be either from each. But the arrangement of the desk was that the computer is here to this candidate, far from just Dr. X moving her chair back, say, 30 centimetres to view it. This one has got to move the chair over a full 2 feet and stick their head round the corner of the divider, So they obviously decided that hadn't happened. But, maybe it did. Maybe everybody in the room was in on this. But remember, the other thing to remember, both of these candidates I think, failed the exam. They only got about 40% right. They were below average. So if this was collusion, it wasn't a particularly effective collusion, let's put it that way.
I have a question here from online, which is quite good. Wouldn't a comparison between the time taken to answer each question by the suspect candidate versus the same for the field be enlightening? Do you have that? Did they have that information?
Yeah, excellent question. When I was instructed, and I would actually ask, is it possible to, if this is an anomaly, to tell whether X is copied from Y or Y can copy from X? And I said, well, if we have timing data given this at a computer exam, I could maybe draw some inference from that. And I told, oh no, sorry, you don't have the data. You can imagine my displeasure when prosecution instructs me, defendant is cross-examining me at the hearing, and we've done this analysis of the timing data. Could you give us your opinion? What? I was told it wasn't available. And this is not the first time this has happened. As an expert witness, you're only given what they think you need. And this is what I have to learn to get better at, not to trust that I have got all the key information. But this one I was really annoyed about. Yes.
My question to the one told her, the year at the same time, like, where's that question? Well, they can know. Is that person thing before there? So you're going to be trying to answer everything in the last 5 minutes based on what written down.
Yeah.
It's somewhat like both the things of all the questions that is probably go back looking for.
Yeah.
They want to find the word.
Yeah. Yeah. That's right. And I think, I'm trying to remember if it was mentioned as to how large the text was on the screen, the distance, from one screen to your eyes, and how large the text, how good your eyesight would have been in order to keep text. Probably the shape of the words, but I can't remember what the point was on that. Do we have any more questions before we hear verdict?
Oh, yeah. Based on how much time do we have?
Right. Actually, we're doing all right on time. Let's have a look. Yeah, we could probably do another 5 minutes.
So I think the next one's down here.
Yeah.
Good.
I just want to. That's it. On opportunity. So we put up in invigilators and given the sort of degree of cover
137.
Yeah. And suppose that they were training them out to see a paper. If it was a few times and if CCTV had records at that, but sort of the number of questions that we're talking about that were team that conclusion on for CCTV not to catch any of it seems somewhat unlikely.
Yeah.
I think this text and then plus back for it. I think that's funny.
The very change big for me. You did your analysis, and I realised it's a common forensic problem. The birthday question: how many pairwise comparisons are? When you gave me the piece of information, then you didn't know that X sat next to Y. But that had a big impact on me because of all pairwise comparisons, you'd suddenly find that S sat next to Y.
Yeah. Yeah. No, it's such a powerful.
You couldn't have known that when you analysis.
Absolutely. No.
You've got two people that showing abnormals, and then you find out they're sat next to each other.
Yeah.
I think that's a bit hard to get your head around. I'm not saying maybe we didn't need to see all 50 answers. Maybe I only need to see 5 or 10 to sway the stats just far enough. I doubt she could have copied all 137 questions, but maybe she only saw a selection of 15 or 20, but that was enough to skew the data from random to, suspicious.
Yeah. Is there anything more online that's worth...
Ian, do you want to come in with online?
There's a couple of questions, but they're mostly sort of procedural things that people would have wanted to know about the case as they went, which is fair enough. Could they use similar material when studying or being similar in some other way? On timings, surely Dr. S must have answered some questions before Dr. Y had answered. And I'm not sure, I think you'll say you didn't have that information, but you would have liked it too. I'll let you answer, sorry. And did they answer both the same questions in the morning and afternoon? So was there a morning and afternoon split between those two particular candidates? And is only one question visible on the screen at a time, or could you see a list of them where you saw that question next, you could change your answer?
Yeah. So the questions were displayed one at a time. It was actually 2 papers, so like 70 odd questions in the morning, and both candidates would have answered the same question, and then in the afternoon another 70 odd, another paper with about 70 odd questions, and both candidates got the same there. So it is one at a time question, but the order, yes, randomised, and that's where I would have loved to have had the timing data to see what that would show. The defence had access to the timing data, which I never did, and I remember being given this, and it was at lunchtime, so I spent my entire lunch break sitting down with a pen and paper, going through, right, have they done their sums correctly? And they had. I can't remember what it told me, but yes, the timing data, I'm sure, would have been quite interesting. Right, I think, final one here.
It's a very minor point. Like the ticket number. Being to different justices, if you sat really needed that, I'd know why if you sat at a distance, you wouldn't be rude, you wouldn't have potential. Just be sitting at a desk. It's like I work at a standing desk. It's a very different every.
Yeah, yes.
You should example. She wouldn't know. That's it.
Yeah. Right. Let's go to the verdict. As a jury, you were basically a hung jury, so this would be a not guilty verdict, civil standard of proof. And the court ruled not true. This, obviously count 2 was proved, but I remember the phrasing, that was incapable of being regarded as dishonesty. So it probably gave her the milder a slap on the wrist, but they ruled that her fitness to practice was not impaired. Obviously, this was the 6th and final attempt at this exam, and I think she would have failed it. But they concluded that it's not more likely than not that she had cheated. So this raises the question, is this case a prosecuted fallacy? Now, what is a prosecuted fallacy? Let's be clear about this. So, when was it, Amy, that this was published?
2017.
2017. So the Royal Statistical Society and the Court College of Advocacy, you can search for this online as well. You'll find it pretty quickly. It's on the RSS website. That one will take you, I think, to the end of Court College Advocacy. And there's a whole document there about the use of statistics in law to advise lawyers and counsel on the usage of this. So what does this have to say? This is on page 25, not page 22. Prosecution fallacy confuses the probability of finding the evidence on an innocent person with the probability that a person on whom the evidence is found is innocent. This can equate to assuming the probability for scientific evidence to match, given the defendant is innocent, is equal to the probability that the defendant is innocent. And for us statisticians, we use the term transpose conditional probability. So the p-value that I was calculating here, this 131 head versus a significant level of 21 head, if the null hypothesis is true, so conditional on the assumption that it's true, there is independent responses, the probability of its observed data is 131 heads, or more. Whereas people might then say, well, actually, the probability that it's null hypothesis, the responses are independent, given that I've had this 122 coincidences, is that, but that's not the probability. And those, when they talk about prosecutor fallacy, this is saying, this is the probability of innocence, in effect. There must be something going on here. But this is not, that's the definition for prosecutor fallacy. So I was fully aware of this at the time of my report. So this is, as always with instructions, you will get a set of instructions to fulfill. But what I always want to see in my instruction is a general, any other comments. And I had it here. And this is where I get the chance to really try and make sure that people understand what's going on here. So I said here, prosecutor's fallacy is an oft-told story that applied to this case. It specifically states the evidence of a statistical anomaly is not by itself proof of guilt. All the anomaly does is prompt an investigation, as has happened in this case. But reading the material provided, it would appear that the parties in this case are aware of this trap and not making this mistake. I was trying to be polite, but I wanted them to have the word prosecutor fallacy in their heads. And the judgment actually does refer to this paragraph of my report. So they were aware of it. The correct way forward is to list all possible explanations you can conceive of for the anomaly, collect evidence for and against each possibility, and then draw conclusions accordingly. Now, I personally have no idea what other explanation other than cheating through copying has been considered, based on the material in my bundle. So I then said, look, you know, I'm a statistician. My expertise was to evaluate statistics, but any statistician who saw this feels duty bound to list what comes to them. You know, and so I'm going to list what I think could be possible explanation, but that is by no means a complete list. I may have completely overlooked it. And it's interesting, just in this room, you've come up with a couple of possibilities I hadn't heard of. So, what were the possibilities I came up with? Well, obviously, there's the freak occurrence one. So the evidence against that is the test there, 122 versus 55 expected and 132 max, not 131 max. Then I also put forward that collusion and revising together. It was only after my report I found out that it was common ground that this was not the case. So obviously, one of the two doctors had cheated. Now, this was important to what I said. One of the two doctors had cheated. Now, the suspicion was on Dr. X here, but that is not for me to say as a statistician. It's for me to say that there could be cheating here. It's for the other evidence to come forward to do that. But I put forward a fifth one. And I'd be interested if anybody can guess what this one is. Note in particular the date, 26th of April. That's when I sent my report of 2021. On the 23rd of April, 2021, a significant legal event happened with repercussions that still occur today in the UK. Can anybody guess what that was? I'm sorry?
Someone to do with Lefty?
No. Nothing to do with the Lucy Letby case. Cast your mind back to over 4 years ago, and it still reverberates today, politically and legally. Interesting. Nobody in the room. Is anybody giving a comment online as to what they think that event is? I'm sorry?
Something to do with COVID?
No, nothing to do with COVID. No one thought of this possibility.
Brexit.
No. It's a legal event, but I don't think technically that is a legal event.
Was it Brexit?
No, it wasn't Brexit. On Brexit. So on the 23rd of April, the Court of Appeal quashed 39 convictions. 39 postmasters have been convicted of stealing from the post office. And they made that quashing. For those who are not familiar, I'm aware that quite a few people from overseas on this call. So the post office scandal, it's just the worst, one of the worst, I think, legitimately say one of the worst miscarriages that this country has ever seen. The court not only said they quashed the conviction, they said the prosecution were an abuse and affront to justice. They almost never say that, affront to justice, that the prosecution ever happened. Because these convictions were based solely on the computer program Horizon and the evidence that came out of the code there. And, and that was the only evidence that they had. And they were convicted and jailed with all the consequences that happened as a result of that. And so we provide an inquiry. The judge is currently writing his main report on what should happen next year. But honestly, I don't know about you when it comes to scandals. I think there's sort of like 3 or 4 layers. You read about a scandal and you might sort of mentally think, oh, that's terrible, but you don't feel anything. It doesn't connect with you. And then you might can't even put yourself in the place of it. And then the next level might be the kind of scandal where, oh yeah, if that was me, that'd be terrible. You sort of feel it in your heart. But the third level, when it hits you in the gut, and this one kicked me in the gut, because I've written so much computer code in my life. Now, I've made bug after bug after bug. And the idea that you could be convicted on somebody's computer side really got me. And that's why I wrote that in my report. Did the wires connecting the CBT used by the candidate get crossed somehow, or was there a software error that caused one candidate's answer to be partially or completely overwritten? It's an axiom. The software program is only as good as the programmer who wrote it. I am not an IT expert and cannot evaluate the software. Now, this is not mentioned in the judgment, so I don't know if this applied. But when I gave this talk at the Academy of Experts in March, there were medical experts. In the end, one of them said there have indeed been problems with the professional exam. There have been examples of the mark being incorrectly recorded and having to be recomputed. So it's not unknown. And I personally tend to this one, to just sheer degree of coincidence. 122. I think even if you were cheating and copying, that was a massive degree. It's sort of like too big. That's why I tend to the computer issue as being the explanation here. That's just my personal preference. So I asked the question, before I go on to this, let's just check the time. Yeah, we're doing quite well on time. You can take questions on here. What do you think? Was it a genuine prosecutor fallacy, or was it actually reasonable to make the case there was something to be investigated here? But in the end, have we people thought on this? I'm sorry.
on Penny Clark was.
No, sorry. I'm not talking about Sally Clark now. Sorry. Let me take that off the screen. I'm still talking about Dr. X here. So with Dr. X, a prosecutor fallacy, basically. Or what do people's understanding of prosecutor fallacy, and is this an example or not?
I like your point that we need to distinguish between when it's reasonable to investigate, and that is quite different from what you then need to present to a court. And your alternative hypotheses, your alternative explanations is very important. I think the other thing, judges, wait for the lawyers to criticize me on this, judges seem to be unable to comprehend that experts are not little silos, that actually we work collaboratively, as you've said. So I think I'm interested that you said you accept the instructions as asked. I don't. I mean, I was confronted in court with why didn't you answer this question? And I said, because it's not a sensible question. Well, why didn't you write that in the report? I said, well, I was embarrassed to write that I thought the court had got the question asked.
I have actually done that, actually, in a case where I said, this is the wrong question. Oh, no, you omitted a question. You should have asked this question. And oddly enough, it turned out to be the most interesting question to answer. So that was just settled last month. But yeah, good point. Anybody else want to make a view on here? And then
to pick you up on sort of your language here. First of all, we need to be dealing with propositions, not explanation. Explanations is a is a set of facts which give you findings. This is the theorising. It could have been this, it could have been that, are all explanations that are investigative, whereas you as an expert need to be evaluative. So in our line of work, you wouldn't necessarily be at court dealing with this could explain it, that could explain it. You get propositions put to you, and then you evaluate them. Now there's a never-ending list of possible explanations. So if I hit the light switch over there, and the light goes out, well, we could say an explanation that was the light switch was working correctly. But an explanation is there was just a bloody power cut, just at the moment I did that switch. You could say, actually, you've got some neurological condition, which means you just thought the lights went out, or there was an alien force field around the light and we all thought it just went out. And you can generate any number of propositions which require coincidental things, explanations, which... So as an expert, you might have to... The likelihood ratio is formed from propositions, it's not for you to generate the explanation, because then you're getting into which of the propositions is more likely, and that is transposed, because you're taking the role of the fact finder. It's the fact finder's job to work out posterior. It's your job to present the likelihood ratio. It's their job to pick the priors.
But what happens if you spot that people have missed something very obvious? And this is what I mean about collaboration. I think that, with Letby, they ignored one of the most obvious facts about the triplets that are monochorionic. Now, just because nobody doing the forensic investigation picks that up, does that mean as a statistician I have to ignore that information?
Well, it comes down to your role in proceedings for me. If you spot something, then you've got a duty to point it out. And the codes say that if you spot something that you think may have contributed, that it's on you to point that out. All I'm saying is I understand for the purpose of what we're doing today, there are these other explanations, but...
No, you're absolutely right on this.
I found that the suspects, DNA match suspect on his gun, and it could have happened because memory transfers could have happened by shaking hands with a thing. It could have happened like they don't set out a whole list of alternative mechanisms by which that DNA might have arrived. What you're doing is setting out a list of explanations which are valid, but what we need to evaluate them in whether we are prepared to discount them.
No, absolutely agree. I should have said propositioned, and that's definitely a learning point for me on that one. I think we'll take some comments from online, and I'll move on.
I was just going to say myself that I think the likelihood ratio quite really interesting, because that getting into the probability of getting that match, given that they cheat. This goes back to what you were saying earlier. That's probably actually quite a small number as well, because what's the chance, given all the issues with how difficult it is to cheat, that they are actually going to get such...
I mean, it's worth pointing out, by the way, one thing I did do, I went through, I subjected all 226,000 pairs to a chi-square test, see how many of those breached at 21 head significance level. There was only one other pair that was on the borderline. Which then raises the question, if this is a software error, why just that pair?
Do you want to take in a really followed from eyes?
Can you hear me? Can you hear?
Yeah.
Okay. There's two questions and then a comment from me. One question relates back to the original data. Did the model take into account that for each question, one wrong option may have been much more popular than all other wrong options? And then, which I think, listening to you, the answer is no, but I'll let you confirm that. And then there's another comment. Doesn't this show the benefit of courts? So now relating to the discussion we've just had, doesn't this show the benefit of courts, tribunals seeking two or more complementary experts whose insight may be relevant. And then if they only seek one expert, it isn't the job of that one to advance theories outside their competence. And my comment was just, how did you get on dealing with this as an individual? Because I agree with the speaker that you had within the live audience there, that it doesn't, we don't have, as statisticians, we don't have models for, what should your prior belief be for computer systems failing. But it's very hard to be involved in these and not, and I also take Jane's point that when you're involved in a team of people and you're working on a case, it's something that statisticians can offer is how we do model things and how assumptions are important and background information is important. And so we do have general insights into these proceedings as well. So how did you cope with that in this instance? Or is this just sort of post hoc analysis that makes for a good presentation?
I didn't hear everything what Ian's questions here, but I did pick up a point about somebody else looking at my work. And so I was the only statistical expert instructed in this case, but in the other case I just mentioned, it was settled last month, that was joint expert. So, I had worked with both of those. It would have been nice to have had that, but I don't think we would have really disagreed much. But having said that, I'll tell you now, and I'm not ashamed to say this, when I tried to build that simple model, naturally I went into our logistic regression, put in the code, and it crashed. And I said, oh, okay. What's gone wrong here? And I couldn't figure out what the error was. So I said, sorry, I'm just doing a simple model here. I'll do it in Excel. But the fit turned out to be very good. So, initially I built that model in Excel, but now I was able to confirm, I had built it correctly, but again, it would have been nice to just some bench checking on this, on that point. But what was Ian's other point that I need to answer?
There is a question about did your model take into account that one wrong option might have been more popular than the other wrong option?
Oh, yes, absolutely. And I built that into the model, yeah. So you could see that very clearly. We've all done multiple choice where, 3 or 5 were obviously wrong, but deciding between the other two. So yes, absolutely, my model took that into account. And of course, the important thing to bear in mind there, if you've got 2 strong candidates, then the probability of them both choosing the same wrong option is lower than when you have 2 weak candidates who are then going to choose that more plausible option. My model absolutely put that into account. Yeah. I think one more and then I'll...
Question in the course.
Okay.
I still have a question about this it's more just a question how you so mention about that. So you've got the model and we use the statistical significance to open an investigation. Do we then consider that model in the evidence going forward, or sort of disregard it and then just consider the prosecution, the defense evidence?
Well, certainly the line that you will see later on that was in the court judgment was, since statistics can't really help us much here, let's move on. So I did all this work and tribunal judgment, it's not really helping us, we're going to move on. I'll show you it later on, but actually this brings up the first connection with Sally Clark. Now, Sally Clark came straight away. When I mentioned prosecutor fallacy in my report there, I immediately thought of Sally Clark. But I had a view of the case based solely on what I've been told by the Royal Statistical Society, other statisticians, including people like Jane, but not the only one. Lots of journalists like to use it as an example how the law is stupid or the judges are stupid and jury can't understand probability and everything. So I built up a picture of what I thought the case was about. And then somehow during while I was waiting to give evidence, some sort of a change happened on social media, and I made a throwaway comment about Sally Clark. It was nothing to do with the Dr. X case or something else. And somebody said to you, that's not right. That's not what happened in the case. And, oh, I thought it was. And he said, no, have a read of the appeal court judgment. So, the end of court document referred to Sally Clark. For those who are not familiar with the case here in the UK, Sally Clark was the mother who was convicted of murdering her 2 children. They were both very young when they died suddenly. And, you know, it was basically, you know, what we now know to be cop deaths. But she was convicted of murdering these 2 and some other women as well. And the thing that nearly everybody knows about this is that a certain prosecution witness, Professor Roy Meadows, asserted that the probability of, chance of 2 children from a professional non-smoking family dying from sudden infant death syndrome was 1 in 73 million. That statistic has gone, I've known that for 20 years, 1 in 73 million, burned in my brain. And so everything sort of led me, this was what I thought had happened in the case. Key evidence for the prosecution was the 1 in 73 million probability of a mother experiencing 2 cop deaths. Professor Roy Meadows calculated it and used it to base it of his expert opinion. It was not challenged and the judge did not warn the jury about limited statistic. The jury was bamboozled by it and unable to see its limitation. And the verdict was only crossed when it was discovered years later that actually there had been tests that indicated natural causes were the explanation for 1 death. Now, that's my understanding, and it could be I'm completely wrong. Just take the sense of the room here. Is that broadly what you understand the case to be about? Am I miles wrong from that?
It was challenged.
Sorry?
The 1 in 73, my memory is it was challenged, and the judges instructed the jury not to take it into
But what about other people? You say that's a fair summary of your knowledge of the Sally Clark case?
Describe Professor actually putting out time.
I'm sorry.
What you've described, press,
Yes. Yeah, that's what I'm relying on here. Yeah.
and there's that somebody's fine
Right, yeah.
said it.
Well, certainly the document I've just referred to, the end of court, does give an alternative probability in it. I think it does. It was mentioned somewhere, I think.
Very good paper, Helen.
I'm sorry.
A very good paper by Helen Joyce.
Right.
Walks through the problem.
Yeah.
I think she ended up saying that the probability that Sally Clark was innocent was about 2/3.
Right.
Something.
Yeah. Right. Now, this is a personal opinion here. So if I create controversy, I don't apologize for that, but I do want to point out the connection about why I've reconsidered. There is a lesson to statisticians here, but it's not this 1 in 73 million. I think it's something else. And this is what the case the Dr. X prompted me to think about this. So let me just check the time. Yeah, we should be okay on time. So what I'm going to do is go through each of those 5 propositions. Now, the appeal court's judgment, if you just go to Sally Clark on Wikipedia, look down in the references at the bottom, you will see links to both the first appeal and in 2000 and the second appeal in 2003. If you have not read them, I strongly recommend you read them. They are fascinating. I learned so much I did not know. So what did I learn from it? So all the text you see on the screen here is just screenshots from, I'll say whether it's first or second appeal. So I'll summarize what this. The key evidence of the prosecution was just this statistic. No, it wasn't. The central issue on each count was whether or not the Crown could exclude death by natural causes. Interestingly, there were 9 medical experts in this case. I think 4 prosecution, 5 defense. I can't remember which swapped around. It says somewhere, all of them agreed this was not a cop death. It was a SUDI, not a SID. SUDI being sudden, unexplained death of an infant. But just because it's sudden and unexplained, the reason why there was apparently evidence of injury on both children. But the defense expert basically saying, well, this didn't mean it's murder. It's just unexplained. Now, remember at this point here, the medical test that had been carried out was never disclosed to these medical experts. Only the pathologist had the raw data. He had done that. He had carried out that test and he had not disclosed it. That did not come out for a year later. So at the time of the trial, they did not have that information. But all experts agreed that this was not SID, a cop death. It was the opinion was that analogy of what resonated, not the statistic. Because I like this question. Would the, I didn't be seriously saying 1 in 70 million to, oh yeah, got guilty. What did it mean 1 in 70,000? Oh no, definitely isn't. No way. Even one that had 730. Jury can't make that by the 50. 4 long odds ran next to winners. Yeah. Now, the third point here is, you mentioned it, Jane, or somebody else mentioned it quite quickly. The judge absolutely didn't want to do it by the limited value of the statistic. He specifically said it would be a terrible day if people are convicted of it. So very clear that it language. However, both appeal court points out that if he potentially confused the jury and direction, very clearly intent to warn the jury not to use statistics in the bank. But he then said something else that could have potentially confused the jury. And both the appeal court picked this up and said, yeah, there's danger here of a prosecutor about the first appeal was not convinced. The second appeal felt, yeah, actually, there probably could have been an issue. But they're not blaming the judge for what he said initially. He was absolutely right in what he said. And you're right, the defendant challenged it. One of the defense experts did say, no, you can't multiply the 1 in 8,000 twice like that. You know, if you have got the probability that that one is higher. So jury heard the defense expert say that. So it wasn't tested in court. Yes, so I talked about this, don't bear it. That's what the better Meadow said. It's the chance of actually that no one outside of Grand National, and this is direct court transcript here. He then said that, you back at the game, then you back at the game, did it 81. Now in a situation where, getting you got 73 million, you've got to back that 4 years running. You might be very, very lucky each time, just being a 1 in 80 chance, happen to have won it. The chance happening 4 years in a row, totally unlikely. The same thing, death. You have to say 2 unlikely events happen to get it very, very unlikely. I've never heard in 20 years since people mentioning the analogy of the statistic. And I actually changed my mind now on Dr. X's case using head value. And I'll tell you why. First of all, this is now another probability analogy, and we know what happened here, and Mr. Carroll judged it. But I can show you these slide later on. I'll explain it. I want to go to the next one here. One challenge. So here, what the judge said, I just think members of the jury just found the word portion of it out of the telling I am baby. Do not make it a report. It be a terrible day after so. In one death family does not mean it can't be another. But that's what we want the judge to say in this case. Just slightly unfortunate because the appeal court's a bit concerned about something else there. Now, here, well, I'll just go back when I saw this there. We're the jury family. We think of jury, lame people, hearing all this expert evidence, not really that educated or capable of reasoning through this. Not a bit of it. At the time, there was mention of this microbiological result, which they discovered years later. And it's quite clear that the CPF did not know about it, prosecution didn't know about it. None of the doctors, the lawyer, and the judge knew about it. The only person who knew was Dr. Williams, the pathologist. And he definitely never mentioned it. It's clear how the jury are interested in that. It showed communications for awareness from their part. And they asked the question, provides the opportunity to reveal, even if they got the wrong answer. But Professor David gave evidence in the possibility case to Christopher. He referred to tests carried out on Christopher. The jury reacted to the argument, are there blood tests now? That one going to have the test for actual audit. Only the jury asked the question, not a student jury. And Professor Williams, well, I'll show you later on, in effect, they went to multiple clarifiers. Why the hell did he not say so? Not that Dr. Williams. You know, and this is the second appeal conclusion here. That, you know, it was disputed. Yes, 173 million is not been wrong. But, you know, it's, let me say it was disputed by the veterinary. Quite watching at all of it evidence will have the jury will never be known, but we rather expect that if the rapid practice, the better about having not a lot of widows, it may have made the effect not expanding it in. I think that tipped them over the edge. I think we had a hung jury here. And that analogizing for probability is what tipped them over the edge. That's my opinion, based on what I'm hearing. The second one, in the judgment. Now, why do I not like the analogizing? Coincidentally, this article on the BBC website about this asteroid venue, you know, they landed a photograph to the field when we at work. Anyway, this is the BBC article. If you search for this, you find it a bit graphic. They're showing the orbits there. And then look what they wrote down here. That the most dangerous rock in the solar system is partly baked in the highest probability of impact work any known was. In terms of time, the chart of the base split came to plotting coin to get their left head in a cloud. My first reaction, I was going to die. That 131 minutes. I thought, yeah, it was bad. I was like, very gut feel reaction. That, you know, we shouldn't be analogizing it. So anyway, that's my review, why I got into this. Oh yeah, this said it. Now my view on the case, you know, there was experts, you know, analyzing here. Jury and judge were on board, not perfect, but were on board. And, you know, the jury questioned the origins in court, then said, oh, the only method of them could be discounted. And the effect people did a lot to understand why that happened. So, any questions? I think we've still got 5 minutes, haven't we? Yeah.
Yep, read anything about using base there?
You
Said using base.
I don't believe my no, it's unfathomable. Now, I want to touch the game, and I told that it's but I said, why started doing a couple of board, a couple of jars, that's composite make time. I learned remember. Yeah, I mean, like, what I heard him say was, no, experts can still use base, but it can't be presented in front of the jury. And then what we do, you're deserting the jury's right to, you know, being to try the fact. That's my understanding of the role of values in Tennessee. Any other questions?
What's the fun of it? The advertising, you can find it famous, and I put them complete. It's the unlikely to know it. That's the thing lottery twice. Really unlikely. That's the somebody doing it. Not definitely, but
It's that
it has happened.
Yeah.
I just say things like, okay, Otherwise, they could take it out from and say, look at the more this. We said they do this on every fest.
Yeah.
But not 600 something. Yeah. Thousands.
Yeah.
Because this one was taking 6 times.
That's why if it's the concept of all you with significant level of 5%, you know, like you said, your certain tax, it's just wrong. You know, because you've got to take into account things like that, they want the context, okay? So no, I mean,
You're not going to analogize or blood it's any here. So the process of management suggest might be ideas as it's not going to use analogy like mob.
Are you not going to use analogy clearly for yourself?
well, I'm going to be very careful trying to avoid, you know, what exactly we're trying to say. So, I came out of directing, obviously, a good idea. I've really done starting to go, dangerous. So, I don't know, I made the question, but I'm going to be vocal.
Oh, God. Business.
I'm ready to tell it about number of times, so confused about one state. So it seems to me that's presenting what I would call joint probability, the probability of two events, you know. But I don't understand why is it that? Why is it not? What's the chance that you have a second child by assuming, given you've already existed one to assume, and seems to be conditional dependence there, and I don't understand why you would use joint probability.
Well, that's the question of the argument, right? It shouldn't be done.
Right.
Not that it's without doing the issue. See, if you read judgment, it's actually clear that prosecution or attendees, well, this is where rather than saying this is the probability of innocence. But the way Roy Meadows used it and failed to explain was one problem. So, you know, it's one thing that the appeal court said, well, we'll talk about the rarity, but it comes up to your point. There are millions of women having, shouldn't be that potentially suffering to death. So are we just randomly picking out one of those? You know, that's the way I would thought of the potential issue. It's like the DNA match possibility. So, in the mission, but when you've got 30 million, there could be 30 matches. So, you know, that's the way I would thought it would affect equality. But I think even more striking example, which mentioned in the court case, or what could the book go, Dave, at the time, the Lucy and Bird case in the Netherlands. The initial probability that they're going to be convicted of 10 that is the elected equivalent case, something like 1 in 300,000 or 1 in million. So, 1 in 300 million, not 300 million. So, 10%, this might be very. When it went to appeal, 2 statisticians got there and they concluded 1 in 26. There was a radically different probability in that case. You know,
Okay, this one.
how are we doing? I think. What about online? You can call question.
There's none online, but there's somebody who's been waiting patiently.
Okay.
On the question of talking about explaining this discussion on analysis, establish those some find land or following by function causing such and trying to find out on doing that we also 6 means it we have to look of child better knowledge. There are 7 not in our miscarriage, but blaming looking at the big thing. If you have miscarriage, you got 2 miscarriages, 1 argument.
Yeah, I know the door.
You know, the movement self help actually from the son seen it before. Okay. Takes big much chapter.
Yeah. The problem that came forward in that is the pathology and the network that seemed to agree that there was unusual injury of a if there was no injury ever humanly solved, it's pretty, yeah. But that we judged that there was apparently some evidence of unusual injury. What did you do? What actually you did?
I think one of the big problems is that we can all say this is unusual, but what we're saying is it's not expected as a real. But that's not the same as saying I've got not the baseline evidence of the right.
Yeah.
And you frequently get people saying, I didn't expect this. You know, I could say, I didn't expect it to rain in the Sahara. What do I know about frequency of rain in the Sahara? I've got an idea.
Yeah. I mean, victims of their event. I mean, people can say don't like the cardiac damage, the like partially dead. The genetic condition that caused it, that should be worked out. So, I did highly recommend. We all genetically live like that, but they haven't. The others.
Right, I think we have to cut it off there because even though we're having a really interesting discussion, but thanks very much, Nigel. Thanks, Nigel. And I will be posting the recording online if it works with the slight technical issues in the middle. Also, we are hopefully going to go for dinner now, so if anyone wants to join for more discussions, they're welcome to do so. So thank you very much.
We're heading to bar.
Yeah.
Okay, thanks everyone. Bye. Thanks, Nigel.